Good morning.
Good morning, Madam Chief Justice, Associate Justices. May it please the Court, my name is Frank Musio. I represent Joseph Reilly and James Georges, the co-executors of the estate of Mildred Dooling and Patrick Curtin, trustee of the Mildred Dooling Realty Trust. We're before you this morning seeking reversal of a decision of a single justice under Chapter 197, Section 10, essentially reviving creditor claims that were not seasonably filed and were dismissed by order of Judge Haggerty of the Superior Court. We raise 5 different issues in our brief. First, procedurally, it is our contention that the Superior Court's dismissal of the creditor claims and the fact that there was a hearing, the fact there was a reasoned decision, and the elapsed time made that judgment sufficiently concrete to be afforded res judicata effect. Second, we contend that, in fact, culpable neglect under 197 Section 10, which was found by the single justice in this case by the attorney representing the creditors, is attributable to the creditor litigants. Third, we contend.
So you disagree with Klubowski?
We disagree with we contend that Klubowski actually is an aberration. It's inconsistent with each one of the cases leading up to the specifically Hastupis, Downey, the entire body of case law that's.
Could I go back to your first question now?
Sure.
In Klubowski,
Yes.
if I understand correctly, the 197 Section 10 petition or whatever complaint was actually filed in the county court after losing in the Superior Court, right?
That's correct.
So why wouldn't, it really is a separate remedy. I just don't see how you would get to a claim preclusion or issue preclusion.
Well, under Grabowski was, I believe, dismissed under 12b-1 as opposed to 12b-6.
Yes, but the footnote says it should have been 12b-6.
Understood. In terms of the conclusive effect that should be afforded the dismissal under 12b-6, given the facts of this case, where we have, in essence, over 2 years elapsing between the time that the litigants learned the statute of limitations had run and actually coming to this court under 197 Section 10. In Grabowski, there was an extremely short period of time. I believe it was 2 months.
Well, that goes to latches. That doesn't go to whether there's a claim preclusion or issue preclusion, does it?
Well, my reading well, yes, I assume it is a latches argument as well, Your Honor. In terms of the res judicata argument, however, we do still contend that given the circumstances of this case and given the procedural posture of Grabowski compared to this case, that the decision of Judge Haggerty is sufficiently concrete to be afforded conclusive effect. The third issue that we raise in our appeal is that in the event that these creditor claims are revived, given the timing, given the fact that Mildred Dooling died in May of 2003, the statute of limitations ran in May of 2004. This petition was not filed until September of 2006, despite the fact that the creditors knew that the statute of limitations had run as early as late May or early June of 2004. Under those circumstances, this case has kicked around the Superior Court, before the single justice, now before this court for close to 5 years. Under those circumstances, if these claims are revived, the estate is potentially subjected in the event of an unsuccessful outcome of prejudgment interest in excess of $1 million. The original claims are $1.8 million. The fourth issue that we raise under the circumstances of this case are that the plaintiffs the creditors lack standing under 197, Section 10. The Monaghan case especially, where a creditor knows they have a claim, and instead of pursuing that claim within the 1-year statute of limitations, they pursue another claim. And when I say another claim, I mean in this case, it was a will contest. Instead of pursuing the creditor claims, the creditors challenged the decedent's will, claiming that there was a promise, and that the decedent was either unduly influenced or lacked the requisite capacity to make a valid will. That case was litigated for over a year, and by the time, and actually the counsel for the creditors and the creditors themselves admit in their affidavits submitted to this court that, and I point to the appendix page 517, paragraph 6, the appendix page 53, paragraph 38, and the appendix page 62, paragraph 35, where each of the attorney and the creditors could admit that there was a decision to not file the creditor claims until after, quote, the will contest was settled or they learned the outcome. So here we have the creditors intentionally sitting on their hands.
Oh, that's not really fair, do you think? I mean,
I think it's fair. I think it's unfair that my client is not afforded the protection of the statute of limitations when, as a proactive executor, filed a petition for probate, committed no fraud, dealt with the creditors forthright.
you were certainly on notice before the statute had run as to their claims because they filed notice of claims in the probate court.
They did file a notice of claim. A notice of claim under 197, Section 9 is a substitute for service of process. What they did is they filed a notice of claim, and in fact they referenced in the notice of claim, if you look at it carefully, a litigation that had been instituted in the probate court.
Mm-hmm.
So, when in actuality the notice of claim should have been filed in the probate court, referencing a case in the superior court that had actually been filed. Nothing had been filed. My clients, although puzzled by the creditor's conduct, was left with no choice but to continue on with the estate. And quite frankly, when you look at this in the context of a will contest and a litigant filing a notice of claim and threatening to file a lawsuit, well, yeah, we were on notice that there may be a case filed, but was there one? No. And when the statute of limitations ran, and the will contest and
What was
The
it?
case was filed in June of 2004, was it not, in Superior Court?
The creditor case.
the creditor case was filed on June 15th, 2004.
33 days after the statute ran. So that's not exactly a huge amount of time.
Well, whether it's we would submit to the court that whether it's a huge amount of time or not is if it was 1 day or 2 days or 1 week, we're still afforded the protection. And for the fact that the estate was aware of the claims, well, certainly the creditors were aware of the claims as well.
The way you described your case, would it be possible for us to distinguish Grabowski from this case?
Yes, I think Grabowski could have easily been decided under the existing rule in Hostupis. It was a classic misunderstanding case. In Grabowski, we have a situation where a minor suffers lead poisoning, and the owner of the property dies. So within the context of those facts, the attorney representing the minor has communications with the attorney for the estate, for the property owners, and is actually lulled into a false sense of security. So between the misunderstanding and the false sense of security, I think it falls squarely within Hostupis. Now, when we're talking about Grabowski, Grabowski is the first instance that this court has ever said that agency rules don't apply. If you look at the standards, if you look at the language in Hostupis, it clearly says that only misunderstandings, inadvertence, or illness will not be attributable to the creditor-client, and then specifically points out that other instances, for example, negligence or breach of duty, you can't, for the court to articulate that standard and then truncate it by Grabowski and saying, well, we're not going to have any circumstances where attorney neglect or breach of duty will be attributed. Why would the court ever articulate a standard that it would turn around and ignore?
Well, one answer might be it's two different courts.
Excuse me?
Well, the Stupa's case is an appeals court decision, and Grabowski is a Supreme Judicial Court decision.
I would point the court's attention to the Downey decision as well, which articulates not as clearly as Stupa's, but certainly with the same force of the two parallel standards. The one standard where we have the carelessness of the creditor-client, and then on the other hand, we have instances that are either inadvertence, misunderstanding, illness, and a subcategory of that, with the inadvertence, misunderstanding, or illness being the circumstances that would be afforded the remedy of 197.
But there is there's an affidavit from, I'm going to mispronounce her name.
Zanadakis.
Which states precisely that it was a misunderstanding.
Mrs. Zanadakis' affidavit
Says everything.
It says everything conveniently. There was no discovery. We never had a chance to depose her. This case, and that's why there perhaps should have been an evidentiary hearing or a master appointed, because certainly Ms. Zanadakis, her conduct reflects a completely different set of circumstances than her affidavit. She filed numerous documents in the probate courts. She says in her affidavit, I didn't even know my client were creditors of the estate. She filed numerous documents with the probate court that clearly identify her clients as creditors of the estate. They cite the statute, Chapter 197, Section 9, which obviously includes the one-year statute of limitations. Whether Ms. Zanadakis either is conveniently forgetting what she did, or is in a situation that certainly if this court awards relief, a malpractice case goes away. She doesn't have to face up to the fact that perhaps there was a mistake. I don't know what the circumstances behind the affidavit are, but I do know what the facts of the case are, and they're wholly inconsistent with Ms. Zanadakis. Excuse me.
But I take it you'll be able to establish that at a trial. I mean, this just sends it back for trial.
Well, the trial would I don't think that Ms. Zanadakis's
But the trial is
conduct
really on the
would be
underlying
germane.
claims.
It wouldn't be germane to.
Oh, I'm sorry. Well, you'd have a trial on the underlying claim.
Now, if this court remanded these issues back to the Superior Court or to a master, then they absolutely would be germane, and Ms. Zanadakis would have to testify.
I understand. I misunderstood your argument.
I apologize for that. From the point of view of 197, Section 10, we will provide a remedy to certain situations not directly attributable to the carelessness of the creditor.
Let me ask you this. She says in her affidavit that she had the complaint filed, et cetera, and that she sought to negotiate. Was there any negotiations while it was before the probate court? Were there any negotiations?
There were very general negotiations. Nothing specific. No offers were made. I do not believe a demand was made other than the notice of claim. I really didn't review the file for those sorts of issues today, but in terms of the overall process that will go on once you have a misunderstanding or you have an estate that is an executor that's consciously misleading a creditor and leading them down the garden path and saying, okay, well, just hang on, we'll deal with you once we're appointed. Then they get appointed after the one-year statute of limitations run, and they drop the curtain and say, no, thank you, we don't have to answer. That's certainly one of the situations that those are inadvertent errors, where there's a misunderstanding like Kostupis, where the statute had undergone 2 successive changes in a short period of time. And this court noted, all the decisions note that there was confusion amongst the bar. Those are legitimate misunderstandings for a statute that's been in place for 10 or 12 years, the entire time that Ms. Zanadakis has been practicing law, and holds herself out as a reputable person, reputable probate attorney. And a year is a year. It's 365 days. There's no contention as difficulty as to the date of death. is no dispute as to when the complaint was filed. Under the circumstances of this case, to allow this back in under these facts would extend the statute far beyond its intentions and would reward a situation where a negligent attorney can escape liability, and my clients are left having to face a claim, having no relationship with that attorney, and having no recourse. Thank you.
Thank you, Mr. Muzia. Mr. Berman?
Do I misunderstand the record here that the Superior Court case was dismissed in June of '05? Is that right?
Yes, I believe that that's correct, Your Honor.
And the petition in this court was not filed until September of '06?
That's correct, Your Honor.
Why is that?
That's a mystery to us as well. You'll see in my client's affidavits that they were not aware of the alternative of filing a petition with this court under Section 10.
Mr. Berman?
Yes, ma'am.
Don't we have here what in other circumstances would be attorney malpractice?
Well,
And
I
aren't
think
there,
it's clearly attorney malpractice.
and aren't there remedies for that?
Well, there are, but as Judge Gertner indicated in the Mullins decision, Your Honor, that should not be irrelevant. And I understand that it's not, this court does not consider that to be any type of precedent whatsoever, but it is a well-reasoned decision. To make that a factor in
No,
whether...
but statute of, I mean, they're, you know, statute of limitations, that's what you learn. It's what I teach. It's whatever, you know, as soon as you are consulted, start learning that statute of limitations. And for an attorney to say, I was confused, and then now it appears that the attorney was also confused about the availability of an alternative remedy, when the one thing that we know about it, the wrapping up of the states, is that the legislature has tried to make as plain as it possibly can. 1 year is a short limitations period, because you can't have people sort of being, you know, waiting for years and years and years until the estate is wrapped up.
Agreed, Your Honor. I think in consideration of the short statute of limitations contained in Section 9, the legislature put into place Section 10.
But the legislature didn't put in place Section 10 to take care of attorney malpractice.
Well,
I mean, it might have taken care of, you know, the mail didn't function. I mean, this seems to me very different from the other cases.
I think
If this theory, if we adopt your theory and say that the attorney's misunderstanding of the 1 year statute of limitations was within the range of ordinary excusable fallibility and it isn't attributable to the client, then wouldn't that apply to insulate most plaintiffs from delayed claims and in effect eradicate the 1 year statute of limitations in Section 9?
Well, I don't think it would eradicate the 1 year statute of limitations. I think
Greatly
that
reduce its
what would
effect.
happen if your court were to consider the potential legal malpractice claim, that would eradicate Section 10, because essentially every case of this nature involves some attorney who didn't abide by the 1 year statute of limitations. In every case that an attorney was involved and Section 9 was not complied with, that leads to a negligence malpractice case against that attorney. Then to rule in that manner would consume Section 10 petitions.
But
It would-
isn't
it would-
Section 10 for special situations, not an ordinary situation, which is apparently what this is?
Well, it's for situations, as stated repeatedly in the case law, where the conduct of the attorney doesn't rise to the level of culpable neglect that can be attributable to the client. Now, the definition of what's normal negligence that cannot be attributable to the client is, as stated in the case law, inadvertence, misunderstanding of the law, which is precisely what Mrs. Zanudakis, did in this case. That's uncontroverted in the record. She stated that she wasn't aware that the 1 year statute applied. And moreover, and more importantly, I would suggest to Your Honors, my clients were not aware of a 1 year statute of limitations.
Yeah,
My
but that's
clients
why you have attorneys. I mean, it seems, again, I'm just repeating myself, but it seems to me that the one thing that is clear, I mean, one thing is clear, statute of limitations, and as Mr. Musio pointed out, here you don't have any knew or should have known where there might have been iffy. You have a decedent's death.
Clearly, Your Honor. But the issue here, under Section 10 and under the case law interpreting Section 10, is not just whether or not the attorney was negligent. It looks at the relationship between the creditors and the estate.
Well,
And there is, I'm sorry, Your Honor, and there is some consideration as to whether or not the creditors should be held accountable for the actions of the attorney. And that involves a determination of whether there's a meritorious claim and whether justice and equity require maintenance of the claim, and whether or not the culpable neglect, which is something more than mere inadvertence, can be attributable to the clients. And you see cases like Leach and Monaghan where the plaintiffs themselves were involved in a decision not to pursue a Section 10 or not to pursue a Section 9 claim against the estate. Those are the situations in which creditors should be precluded from pursuing the claim.
May I just ask you this?
Of course,
I suppose it's already been asked, but I'm just kind of puzzling over this. If we agree with your position, doesn't it mean that whenever there's a statute of limitations, that a lawyer could say they misunderstood it?
Well,
And wouldn't it, if we agree with you in this case, wouldn't we have to always agree that a lawyer could say that they were confused or they misunderstood the law?
I don't subscribe to Mr. Musio's position that attorneys that are members of this bar are misrepresenting to this court or any court what their reasoning was or what their position was. If Ms. Zanodakis indicates that she misinterpreted the law or wasn't aware of the one-year statute of limitations, that's uncontroverted on the record. And to suggest that somehow her affidavit obviates that, I think is somewhat offensive to her.
Isn't the answer also, though, that unlike the normal case where a lawyer blows the statute, I mean, any case, in this case we have a specific statute, as in Section 10, that offers a remedy. I mean,
Precisely.
you know, it's not so.
Precisely. It's not the normal case where an attorney has not abided by a statute of limitations.
The statutory rescue doesn't exist in other circumstances.
No, I understand that. I mean, otherwise we wouldn't be here. In Grabowski, one of the things that we said was that the estate, the delay of the estate had not been prejudiced by this. Mr. Musio at least makes an argument here, and I think in his brief, that the delay really has prejudiced his clients.
Well, I don't believe that it's the type of prejudice that the court has previously considered in the context of these types of cases. The Hustapis case, as well as the Mullins case, again, a federal court case, have indicated that under circumstances as here, where the estate is put on notice of the claim within the one-year statute of limitations, that it's very difficult, if not impossible, to prove any claim of prejudice whatsoever. I think the prejudice relates to the notice of the claim. I mean, prejudgment interest, that applies in any case in which claims have been reinstated.
But couldn't you say, in this case, since this is a bill in equity, and it's really, the statute has, you know, if one goes this way, sort of given you a life rope, or whatever I'm trying to say, that perhaps equity demands that you not get in, I mean, assume you prevail on the underlying claim, or your clients do, that equity would demand that interest back to the date of death not be awarded.
That's an issue which we'll address when the time comes. I did not research that. My position obviously would be that we would be entitled to prejudgment interest, but that's something we would have to research.
Aren't you just looking for the property here? Is there something else you're looking for, cash in addition to the school?
Well, there are quantum
not
merit
entitled.
claims, Your Honor. There are two claims. There are claims
Certainly,
that
they're financial claims.
Sure. There are claims that are certain equitable interest in the land.
And those claims have survived?
Those claims have survived.
So they're still pending?
They are still pending.
They didn't need 197 Section 10 to be revived?
The underlying court ruled that was not applicable.
How could your attorney believe that you were not creditors? She wrote, I believe, in her affidavit that she believed, but her filings in the probate court refer to you as creditors.
I couldn't speak for Ms. Zanodakis, Your Honor. I mean, mean, the entire affidavit, I think, shows respectfully to her, and I'm not one to criticize another attorney, that she had no understanding of the
Well, then,
statutory scheme
isn't that
was
a
in place.
reason that that there are underlying facts here that couldn't be resolved by the single justice, because her affidavit, at least to me, is very confusing and contradictory?
Well, the standard of review here is abuse of discretion or clearly erroneous.
Is it really?
I-
This is a 19710. Why is the standard that? Isn't this a decision for the whole court to make?
I don't dispute that Your Honors are entitled to find, well, actually, I do. I take that back. I don't think it's disputed that the standard here is abuse of discretion. That's the standard that was articulated by the appellants, which
Well,
we adopted. I think
Well, they take a different stand. No, well, then that's not what they say in their brief. They say this is 19710. This is specifically a decision that the Supreme Judicial Court is assigned to make.
in the statement of issues, they make reference to reversible error.
All right, well, in any event,
Reversible error by not ordering an evidentiary hearing and so on.
you agree that on the basis of this record, we as a court can make additional findings of fact.
Yes, but I would think that the decision of the single justice is to be accorded great weight, and it's our position that unless this court can find, based on your review of the facts in the record, that that finding was somehow clearly erroneous, that finding should stand.
Well, I may be wrong, but I read you as implicitly saying that the affidavit is contradictory within itself.
I don't adopt that. I mean, I don't dispute the fact that she says that
One thing and then says another thing. So
Sure.
then how can the single justice make findings?
Well, if the single justice concluded, based on that affidavit, that Ms. Zanoudakis didn't understand the applicable statute of limitations, didn't understand the statutory scheme that was in place, which is clear from that affidavit, he could then conclude from that and infer from that it was inadvertence or mistake that led to the failure to abide by the one-year statute of limitations.
Or in any event,
That is what
should-
that affidavit is, I think, is a misunderstanding of the statutory scheme that controls this type of case.
Mr. Berman, let me ask you this if I can. It's here.
Oh, I'm sorry, Your Honor.
What is the status of the quantum merit claims?
They're pending. We are waiting a trial date.
I mean, nothing has been stayed.
Nothing has been stayed officially, Your Honor, but we have been going in periodically for status conferences pending the outcome of this case. Because there is a sister case that relates to the legal malpractice, which, if this court reinstates the underlying claims,
What is the sister case?
it's Gates and Russell versus.
So there's a third action?
There's this action,
Right.
and then there's a legal malpractice claim which we filed because the statute of limitations was beginning.
And then where's the quantum merit? Where's the leftover piece of the...
That's also in this case.
Well, that's in the Superior Court.
Yes, Your Honor.
And
That's-
is
well, that's what I
Is that a
call it.
quantum merit? It's quantum merit, that's what it is?
There is a quantum merit action. There's a promissory estoppel claim, and there's a couple of other.
Is there a
equitable-
challenge?
When you say there's an equitable, your attempt to enforce an equitable interest in the school property, what kind of claim is that?
That would be an equitable claim.
Okay, so those are all pending, having nothing to do with 19710. So it's not like there isn't a remedy here for you.
Well, there's a remedy, but in our view, it's a much less desirable remedy because in the context of equitable claims, the trier of fact would have to conclude that we're entitled to everything or nothing. There is no middle ground there.
Mr. Berman, let me put it this way. With what has survived in the Superior Court, that part that was not dismissed by the Superior Court judge on statute of limitations grounds, is there a challenge to the disposition of the school, of the property? I mean, is this an attempt by your clients to set aside the will?
Well, that is an action that has already taken place. They challenged the probate of the will. That was unsuccessful.
Unsuccessful by whom?
On our part.
By your clients?
Right. We weren't able to set aside the will. I was not involved at that point, but predecessor counsel was unable to have the will set aside.
And that's what the defendants are claiming, is that you waited to see what would happen in that suit before you began this suit.
That's speculation. There's nothing in the record to suggest that. And in
I'm
fact,
trying to figure out, so that you've lost that, so how do you get access, and that's where the school was left to all of the nephews and nieces, correct?
Correct, Your Honor.
And what has happened, is the executor just holding on, disposing of that?
There's an injunction in place.
There is an injunction in place which enjoins the sale or encumbrance of the property. The school is
Is it
an
operating
ongoing
now?
entity.
It is?
Beth and Kate are running the school. It's a profitable enterprise. This is their life work of 40 years, and they're going to continue to do it for as long as they possibly can.
If they prevail on their quantum Melwood claim, I'm going to call it quantum Melwood because it's for the work that they did, correct?
Yes, Your Honor.
In essence, that's their claim, right?
Yes, Your Honor.
And if they prevail, and have they sought relief that the school be transferred to them?
School and the land upon which it sits, Your Honor, and that's based on the promises that were made by their Aunt Mildred Dooling.
But what isn't,
Not
wouldn't there
with-
be a
not with-
statute of
not with
frauds
sta-
problem there?
I'm sorry, Your Honor.
Well, two things. One, notwithstanding the conclusion of the probate court that this was that they couldn't set aside the will, correct?
Yes, and I think that was based on a claim of undue influence. This is something completely different. It's actually based on the fact that the will did not contain a provision which left them the school.
What is the basis, if they get a monetary judgment, what is the basis for having a conveyance of the property to them as opposed to having the property sold to pay whatever damages may be due to them?
But that's an issue that needs to be resolved. I think it depends on whether or not we're successful on the equity claims or on the
And the equity claim is?
Claiming an equitable interest in the land based on the promises that were made.
Notwithstanding the fact that she changed her will and that will has been held to be valid.
Correct, Your Honor, yes. It's the fact
So
that
that if I promise you, the theory, I'm just trying to understand the theory. If I own a school or building and I promise you that I will leave it to you, and then in my will I leave it to somebody else, and you try to set aside the will and probate court rules against you, you nevertheless think that an equitable claim survives?
yes, and I think if there's a section in our brief which sets forth a plethora of cases under exactly those circumstances where somebody provides a service in exchange for a promise to be included in a will, they're not included, and they're entitled to claims under equitable theories.
They may be entitled to monetary damages, right? They may not be entitled to the school.
Well, that's an issue that's somewhere down the road, Your Honor. I don't dispute that is an issue, and it may very well be that in the event that our claims are reinstated, we'll have to consider whether we want to continue with the equitable claims. I can't make a representation as to that at this point, but it would be cleaner, in my view, to have the underlying claims reinstated and go forward on that basis. I think the equitable claims were put in place in response to the dismissal, in response to the fact that they had not abided by the one-year statute of limitations. They were trying to be creative in maintaining the cause of action, and that's also part of the reason why my clients were lulled into a sense of security by predecessor counsel, because they were incorrectly advised that the equitable claims would protect their interests, which in fact they don't completely. It's more difficult to prove.
Thank you, Mr. Byrne.
Thank you, Your Honor. I'm all done. Thank you.